Good morning, Your Honors. The matter before the court this morning is the case entitled Danielle Lacroix versus Peter Rysz, case number 25 AP 281. Representing the appellant, Peter Rysz, is attorney Joseph Tremblay. Representing the appellee, Danielle Lacroix, is attorney Sharon Ennis.
Thanks very much. Good morning, counsel. We'll hear, of course, from counsel for the appellant first. Of course, please start by introducing yourself and your client and then proceed.
Thank you, Your Honor. May it please the court, my name is Joseph Tremblay and I represent appellant Peter Rysz. So in October 2021, the Family Division issued a parenting plan that awarded Mr. Rysz approximately 43% of parent-child contact with the party's minor child, who at present time is almost 12 years old. In July 2025, the Family Division further reduced father's parenting time based primarily on its finding that father's behavior, quote, negatively impacted the child. The Family Division failed to articulate how the child was negatively impacted, whether any negative impact rose to the level of the significant emotional harm required by statute, or how father's behavior was the cause of the negative impact, if any. So understanding and accepting that the Family Division has the power and authority to determine what is in the child's best interest in the first instance, that needs to be coupled with the understanding that the Vermont legislature has already established as a matter of state policy that it is in the child's best interest to have, quote, maximum continuing physical and emotional contact with both parents under 15 VSA 650, unless, quote, direct physical harm or significant emotional harm is likely to result from such contact. After the initial best interest determination was rendered in October 2021, finding that 43% of parent-child contact was the maximum continuing physical contact warranted, the Family Division should have been required to find that actual physical or significant, and that's the key, significant emotional harm either resulted or was likely to result before modifying the PR&R order and further limiting father's parenting time. So, putting aside whether the Family Division employed the proper standard when it reduced father's parenting time based on its determination that the child was negatively impacted by father's behavior, the analysis as to whether physical or emotional harm has resulted or is likely to result from further contact should, under the law, require a level of evidence that goes beyond that which is necessary to support that initial best interest determination. Our contention, Your Honor, is that the law should require, the proper analysis should require either one or both of the following at a minimum. Either direct testimony from the minor child who is subject to the order and or testimony from a qualified mental health expert who has personally evaluated the child, rather than the court relying on the self-serving statements of two parents locked in a bitter parenting dispute. So the Family Division has the power to call a minor child as a witness and to appoint an attorney for the child under 15 VSA 594A and B, and is contemplated by Vermont Family Rule 7. And in the 2022 case, Vance v. Locke, this court specifically noted that a, quote, high level of acrimony and alleged interference with custody or parenting time are two factors that, if present in a custody case, weigh in favor of appointing counsel for the child. In this case, it appears the Family Division didn't even consider calling the child as a witness. But beyond that, and more importantly, the Family Division lacks the specific expertise to conclude that it was father's specific conduct that caused any particular impact without expert testimony to support that causal connection. An apt comparison would be medical causation. Sometimes an injury and its cause are such that the causal connection is obvious, but as this court held in Egbert v. Book Press in 1984, quote, where the causal connection is obscure, expert testimony is required. To that point in the 2018 case Sweet v. St. Pierre, this court affirmed the trial court's exclusion of any lay witness testimony that the defendant's severe emotional distress was caused by an alleged assault, because, quote, expert testimony is ordinarily required to prove medical causation. So while there may be some extreme examples where significant emotional harm is obviously causally connected to certain experiences.
You have 1 minute, counsel. 1 minute.
Thank you, Your Honor. More often than not, the changes in a growing boy's behavior and the reasons for those changes aren't going to be obvious. And given that the Supreme Court has determined the U.S. Supreme Court has determined a parent has a fundamental constitutional right to parent their child in Quillen v. Walcott in 1977, and then again in Troxel v. Granville in 2000, The family division should have required the presentation of expert testimony to support a causal link between father's purported behavior in the child's presence and the impact, if any, that behavior actually had on the minor child. Thank you, Your Honors. I'll reserve whatever time remains.
Okay, thank you very much. We'll hear from counsel for the appellee now. Please start by introducing yourself and your client and then proceed.
Thank you, Chief Justice. My name is Sharon Annis, and I represent the appellee Danielle Lacroix. And I'm here to ask the court to affirm the ruling of the trial court. I think it's important to review the standard, which is reviewing the evidence and ruling in the light most favorable to the prevailing party, which is the appellee here. There are no grounds to overturn, reverse, or modify this order. Our position is that there was clearly a real substantial change of circumstances that was supported by the evidence presented, and including very clearly the original parenting order that found that father had committed to and was starting to demonstrate being able to respectfully co-parent with mother. That is in the court's discretion to find that change of circumstances, and they did, and that holding should be upheld. Father or appellant, as the court in July found, was unable to continue that cooperation or respectful co-parenting. And there was a myriad of findings to support that ruling. So I think that that is fully supported, and in that case, the court has to affirm that. The overriding issue and finding of the trial court was that the child is not shielded from appellant's feelings and is surprisingly negative impacted by the conflict this creates for him. That doesn't mean that the child has to be directly present when the two parents or the effect of one parent's treatment of the other is demonstrated. It's what's flows through to the child. And that is what the court made very significant findings on in the order that was issued this summer. Mr. Tremblay did not.
Attorney Annis?
Yes.
Attorney Annis, I apologize for interrupting you. So what is your, well, let me just say this. Attorney Brennan argued that the court should have called the child as a witness. He is 12 years old, and the court did do an analysis. Was it necessary for the court to hear from the child?
No, not at all. And the clear practice and policy supported by the Law and Family Court is that children should be called as a last resort only, and in extremely rare cases. Calling a child to testify as to what behavior their parents have exhibited to each other and how that affected them. One, the child is not qualified to make such a determination, and it is emotionally harmful in and of itself to call a child and force them essentially to pick between parents and put them in the middle. They're kids. They don't know any better. They want to please both parents. The policy behind that is strong and strict, and appointing an attorney for the child doesn't make that any better. There is more than one reason for the court to appoint an attorney for the child. And in this case, if a motion had been made, which the appellant did not make, attorney for the child might have been appointed simply to be able to participate in the hearing, bring out evidence, ask questions, and present their own evidence. That didn't happen. But the notion that asking a child who is already being influenced in one way or the other, negative or positive, and from both parents, is not going to provide any probative evidence to the court and runs the risk of emotional harm.
You have 1 minute, counsel. 1 minute.
Thank you, Your Honor. And I will say, moving forward from that, expert testimony should not be a requirement either. The case law is clear that expert testimony is advisory only. It may be helpful to the court, It may help elucidate some of the questions, but it does not replace the judgment of the trial court and the discretion using their common sense and judgment as well as their judicial skill and experience to make that determination. Requiring expert testimony or requiring a child to be called in such circumstances, of course, we could follow that slippery slope argument. But most importantly, the child should not be traumatized as part of a process where the parents already are not getting along. So thank you very much for the opportunity to argue today.
All right, thank you. Your time has expired. Does the appellant have time?
Appellant has 16 seconds remaining.
Counsel?
Thank you, Your Honor. So just to make a very quick point, we disagree with the fact that there was that the court was capable of finding a substantial change in circumstances based solely on the fact of its findings in the 2021 order. The court can find a breakdown in cooperation can only support a modification of parent-child contact to the extent the order is premised on shared expectations. This was a very hard-fought parenting case. There were very few shared expectations, and to the extent there was a shared expectation that Mr. Rysz wouldn't exhibit negative behavior or words towards Miss Lacroix in the presence of the child, there was no evidence presented at trial that would support any finding that he did that. Quite frankly, there's been no change of circumstances, and we addressed that in our brief as well. And then finally,
Yeah, go ahead, finish.
Then finally, Your Honor, the court did not make any specific findings as to the negative impact on the minor child. As a matter of fact, and as we note in our briefs, the court focused almost exclusively on Mr. Rysz's behavior towards Miss Lacroix, and where the consideration is the child, that was improper and warrants reversal.
All right, thank you. Your